contestation, both that initially the person whose decision it rests with to expropriate land is the Minister of Public Works. However, it does allow for it to be extended all the way to the courts, and for the courts to have the final verdict. Now, given the way the courts are progressing and the way the courts are dealing with it, it is imaginable that they will be, how they deal with it, imaginable that they would probably deal with it in a very liberal sense. However, if we look at some of the justices who are currently sitting, off the record, I actually have a lot of faith and a high opinion of a lot of the Constitutional Court judges. They dealt with a lot of the matters that have come before them in the recent months very, very well. I believe that they would deal with this fairly, and they would take into account to a great extent the requirements both of the individual people, as well as the requirements for expropriation of land and for the requirements of the state and the purposes. So how the court's going to deal with it becomes very interesting. Another important element to remember when we're talking about expropriation is that, as those of us who are in the sales industry know, that what's most sales of properties dependent upon? Bonds, mortgages. That whatever's done cannot be done which is going to prejudice the banks granting loans, because, and we've even seen this, we've even seen this adaptation from the courts already, that they've already taken cognizance of the fact that mortgages have to be respected, because in order for an economy to function, money has to be loaned in advance. Banks need to get security over the property, and to the extent this is even recognized from 1998 when power was already promulgated, because certain of the criteria which exist in carrying out an eviction don't necessarily apply to persons who default on mortgages. It's very interesting that theoretically, a person who's completely illegally occupied land and a person who's defaulted on his mortgage, the first person, the guy who's completely illegally occupied land, theoretically has greater rights and considerations than a person who's defaulted on the mortgage, which is actually very interesting.
If there's no bond on the property,
pardon?
If there's no bond over the property, then it's quite easy to evict.
For an eviction? Well, for an eviction, if there's no bond over the property, then it becomes complicated, because in order to remove somebody from the premises, a person can only be removed from the premises if they lack a legal right to be there. In order for the mechanism of power to be activated, one has to be in a situation of being an unlawful occupier. So if a person has no bond over the property and they own the property, it becomes very difficult to, it becomes almost impossible to evict them. Okay. However, if we look at expropriation in the context of a mortgage, and this is what's something that's new to the expropriation bill, is that it takes into account this element of mortgage, because banks need to also be taken into account, because you can't be in a situation where banks are going to be prejudiced, because if the banks are overly prejudiced, then they're going to turn around and say, I'm not going to be loaning money for people to buy houses, because I'm not guaranteed of having a return on my investment. And if the banks leave the property market, then there's no property market, ostensibly. However, it's with this in mind that the expropriation bill has come very much to the forefront, and it says that the banks and all persons involved need to be taken into account. So whilst expropriation exists and the mechanism for it to be brought about is now being put in place, the question around how it's going to function is now being, because now it requires that all persons all role players in the game have to be involved. So in other words, if we return to that little example of ours, whereby we're going to try and expropriate land from the whole of Strathaven, we now have to potentially have the involvement of all the banks, everyone involved, because the banks have to know that if the land is going to be expropriated, that their investment has to be compensated for. And something else which has occurred, which is very interesting in terms of this new bill, which actually gives me a level of cognizance, a level of appreciation for the bill, is that the bill doesn't just recognize persons who have registered rights over the property, right? It recognizes persons who have unregistered rights over the property. This means that if you say that we want to expropriate land, that means that the person who theoretically owns the land and the bank have to be compensated, as well as any other people theoretically involved. In other words, a person who's got theoretically a right of way over the property, which in other words they've got a right to traverse the property as needs be. Potential tenants on the property, right? He's got rights and interests in the property. Persons who maybe work on the property. All those people have rights and interests in compensation. Which does, however, lead us to another question, which I'm not going to unpack, which is, who's going to fit the bill? Right? Which is something that needs to be taken into account and needs to be considered. Now, those people there are a lot of people who suddenly become very, 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 very paranoid about the expropriation of land, about the expropriation bill. And my answer to them is very simple, that expropriation of land is nothing new in South African law, as I said before. The Expropriation of Lands Act existed as early as 1976. And it was a tool which allowed for a great manner of abuse, right? And the considerations in terms of that act, it did mention that the main considerations were the amount which the property would have realised if sold on the date of notice into open markets by a willing seller to a willing buyer, and the amount to make good on actual financial loss caused by the expropriation. There are one or two other things that are taken into account. And in fact, I've actually seen it quoted by other authors that they say that this new bill is in fact far less draconian than this original 1976 bill, which is currently, with the current 1976 Act, which is currently in operation. So when people are running around and they are panicking and they are like, oh my goodness, let's pack our bags and run to Sydney, the truth is that that level of paranoia isn't necessarily justified, because if you look at it, this expropriation of land, the new expropriation bill provides far more rights and far more considerations than its predecessor ever did. In fact, its predecessor made no consideration for other people involved. It purely focused on the person whose property it was, right? Also bear in mind that a very common misconception is that when we talk about the expropriation, the Expropriation Act, and it's been promulgated, the Expropriation Bill, that there's something very important, that it's not purely speaking about immovable property. And both acts make it clear that they're not speaking about it. That means that they extend to all manners of property. So everything is open to a degree, to a level of expropriation. So just to advance it and to start working towards some of the conclusion that a lot of these elements that are existing are nothing new to South African laws, as we can see. That what's happening is that there's a lot of talk and there's a lot of rhetoric which is floating around, which isn't necessarily taking into account one, current legislation, most importantly the Constitution, and it's not taking into account the bills which are being promulgated. Parliament itself at the moment is trying to get this bill through. Now, whether or not this bill passes this year, next year, or following the elections, it is up for debate. But it will have to come through and will have to be obviously digested, interpreted, and applied by our courts, which we obviously need to have to see. That I think as property owners and persons who are involved in the property industry, we need to understand that there is going to be a level of concern, a level of paranoia, which isn't justified, I don't believe. That the mechanisms which are in place and which have protected, call it the functioning of society, specifically the Constitutional Court, are and will continue to function and are going to digest this and to apply it appropriately. However, from another perspective, that the redistribution of land and the proper distribution of land to remove and to adjust historical inequalities is necessary, and it has to be interpreted and it has to be applied. How it's going to be done is obviously something that we're going to have to stay tuned for. The important thing to note, though, is that the framework that exists is that the mechanisms are in place that it has to follow a legal and a societal model that shouldn't unduly or unjustly infringe on persons' property, on persons' interests and rights, which is something that's very encouraging. Yeah.
Mr. Millner, may I please ask you, talking about property, what about the 3-story house and the swimming pool and the 2 granny flats, and will they take that into consideration as well? Because they do spend, this person has spent a fortune building up the property.
So that is dealt with by the Act, by the new bill and obviously the Act, right? That obviously one of the things that has to be taken into consideration in both the historical expropriation of Land Act and with regards to the new expropriation bill is the current use and the current value of the property, right? So in other words, that it becomes problematic if, let's say, a property is worth 3 million because it's got 3 flats and a pool and this and this and this and this. And when the expropriation committee approaches, they say, look, we're buying up the whole area. Obviously, like we said before, it has to follow the framework. It has to comply with the rules of general application and everything like that. It has to follow that framework. And if they turn around and say, we're offering R1 million, right, that's where the problem is going to come in. Now, it's more than likely that a property of that nature won't necessarily just have a bond of R1 million, and they have to compensate all the people. Now, obviously, there might be people living in the granny flat, right? Whoever they might be, tenants, whatever, tenants, relatives, whatever, all of whom have a right to compensation in terms of the new bill, right? So also that's where it opens the door for it to be adjudicated by the courts. And the court does rest with final adjudication. There are stages in between, whereby there's periods whereby the original expropriation offer is made, then there's an opportunity to dispute, then there's an opportunity to go backwards and forwards and to have settlement negotiations, then there's also an opportunity for the expropriation committee to reconsider their offer. If they want to expropriate their land, they might turn around and say that to buy the whole suburb of Strathaven out, it's going to cost, it's not worth it. We'll rather just move down the road and we'll go to Bryanston or we'll go to Morningside or something, right? Which might be a consideration, right? So it opens the door to an entire economic discussion and an entire arbitration. So it will end up in some kind of determination. Obviously, for those scavenger lawyers out there, it potentially holds possibility of opening the doors to a degree to everyone's favorite creature, which is litigation. Because there is going to have to be a level of determination. Someone's going to have to prosecute this and to have this determination. Now, if you can imagine, if we work on a hypothetical model where someone turns around and says we're going to expropriate the whole of Strathaven, let's say there's 200 people living in Strathaven. If no agreement is reached by the committee, that you potentially leave the door open to 200 separate cases being prosecuted in court and seeing other court. But however, that does mean though that once it's in there, that ultimately a determination will be made. It will take into account various things, and one of the things that it takes into determination is whether or not the property and the purpose for which it's being expropriated are simultaneous. So in other words, if we're saying that we're going to expropriate Strathaven because we need to build low-income housing and we need to develop an entire low-income community, which includes schools and whatnot. So this guy who's got a $3 million house, they might turn around to him and say, yes, theoretically your house is worth $3 million, but we're buying this land from you, and then we're going to bulldoze it, and we're building a school there. In which case, that is something that the expropriation committee, that the expropriation committee makes the initial discussions, and later the court, when it makes the final determination, will have to adjudicate upon. So it will become interesting. But let's see. There's a lot of, for want of a better word, pandemonium pandemonium is a bad choice. There's a lot of panic that's sweeping its way across the country at the moment for whatever reasons, due to political uncertainty, whatever.
The demonstrations.
Pardon?
The demonstrations, they've led.
There is, and there's a lot of talking, and there's a lot, and to a large degree that what they're saying is correct, and it's issues that has to be addressed, and it has to be addressed properly, and it seems like the fact that the bill's progressing and that it's starting to be applied, that it is starting to be addressed and it is starting to come into it. Are we at the point where we've got a finalised product? No. Are the issues out there being addressed or starting to be addressed? Yes. Is everyone going to sit down at the end of this in 10 years' time, 20 years' time, 30 years' time and say it's exactly what everyone was promised, what everyone hoped? We'll have to wait and see. But there's a large area where I believe there's no need for panic, where there's opportunity, where there's need to be responsible and diligent in consideration of what's going on and what things are being promulgated. And importantly, there's a need to understand that the country's going to function, things are going to behave, and whilst the currency and whatnot might fluctuate, the property in and of itself, whilst there has to be redistribution, that the framework is in place, that it's done in what should be a proper and fair, and to quote the most important phrase from Park, that justice and equality, justice and equity is going to be applied. And that means that it's going to be applied across the board and everyone's going to be dealt with fairly, because like I'm saying, there's a lot of very good judges on the bench, some very interesting judges who especially in lower courts we've had fun run-ins with, but there's a lot of very good guys, especially once you're starting to talk about that higher level who are going to be required and are going to be called upon to make big landmark judgments. I'm talking about your SCA and your Constitutional Court. There's guys there who know what they're doing, who have shown from the history leading up to them ascending to the bench and their actions whilst on the bench, that they understand the needs of the country and that they're out there to protect it and they're looking after it. Thank you very much. I'm happy to take questions, yes.
Yeah, just could you talk maybe about, not about urban areas, I mean, obviously that's what we're mostly here to talk about, but I'm curious as to how this would affect farms, redistribution of land, sort of the fear around what happened in Zimbabwe where lands were sort of taken away. And you've kind of addressed that, but how would that relate to farms?
Thank you. So that is interesting. I did predominantly focus the discussion upon urban areas. But agricultural areas are something that have to be considered. It's very interesting to note that even under current South African law, that agricultural land isn't dealt with the same way normal land is dealt with. That, as I said to you, the act that governs normal evictions is the PI Act. However, when we're talking about agricultural land, you're now talking about a completely different act, which is called ESTA. And ESTA is, however much people call it complain or bewail the difficulties in Park, ESTA is completely different. ESTA was created and was promulgated to protect instances where you've got persons who work on agricultural land, and some of them have worked there and lived on that land their entire lives. And sometimes even they'll have situations where their relatives have worked there before them, and they'll have family graves on the sites and things like that. So ESTA takes the entire framework into a completely different level. Excuse me, and the requirements to carry out an eviction and to deal with evictions are very different than PAR. And even the categorization of an unlawful occupier when you're talking about in ESTA compared to what you're talking about with PAR become very different. And the rights become very, in fact, ESTA was in front of the Constitutional Court, it was in the last 2-3 weeks, it was before the Constitutional Court. And there were instances even where, now in power, there are requirements upon us where we have to make allocations with regards to alternative accommodation, which, you know, your savvy lawyers will turn around and say, look, there's alternative accommodation at like we're saying prices as to what the legal occupiers should be paying, and that's fine. Esther, it doesn't work that simply, right? Esther puts much stronger requirements on the person who wants to carry out the eviction, right? And it isn't even clear that and sometimes they have to make proper allowances for alternatives. They have to purchase and promulgate and to bring about this alternative accommodation. And one of the things that happened when the matter was lost before the Constitutional Court, the Constitutional Court turned around and said that the land that had been made available by those owners wasn't acceptable. And it wasn't talking about people who are currently working for the people who own the farm. I was talking about instances of people who have ceased working. Okay? So now, when that comes into account with regards to the expropriation bill, the expropriation bill would change that framework, because now, theoretically, there's your owner of the farm who has to be compensated. There's his bank that needs to be compensated. There's all persons who have registered and unregistered, which is something that is very new to this act, that you don't require these rights to be registered, right? So now that all these persons residing on the land, be they current labourers, former labourers, children, descendants, relatives of past labourers, all of them, in terms of Esther, now have to be compensated.
That seems like a minefield. It seems almost impossible for the farmers to be able to hold on to their land given that situation, if their land is wanted as such for redistribution. Look,
so it becomes difficult. So look, the truth is that what changes is that there will have to be an element of, but also what will come into it also is that, like we said, when the redistribution when the expropriation committee initially approaches the property, they have to make it clear the purposes for which they're going to be purchasing the land, right? Now, if I turn around and I say, I'm going to purchase a farm, which currently produces however many thousands and thousands of products, which feed the country, and I say, look, I won't expropriate the land because I feel that in the middle of Mpumalanga we need to build a brand new shopping mall, right? It's unlikely that would pass the test, one, of general application, and two, it definitely fell in arbitrariness and would fall on other of the factors, right? Beyond that, let's say somehow they overcome it, because they would still have to secure it for purposes of some kind of of agriculture, right? At the expropriation, they'd have to say who's going to be expropriated and to whose benefits it's going to be expropriated for. And also what's going to happen is it's going to be that all the parties who I've mentioned have to be adequately compensated. So your big question is that and that's probably where the greatest thrust of expropriation of land is going to fall, is going to be in the agricultural sector. It's probably not going to impact on your urban environments as great. It's probably going to hit the agricultural sector. And now you're going to be in a situation where, let's say that this farm potentially, hypothetically, is worth 10 million rand, right? Let's say there's a bond over for 9 million rand, okay? And let's say that there's 30 farm labourers on that property.
Each one's earning an income.
Do the maths.
Yeah.
Everybody has to be compensated. All of them have real rights. Now the truth is that there's something that has to be done and government has to do it. So now the question is going to be,
I can't afford it.
where's the money going to come from?
Government.
Because a prerequisite in terms of the Expropriation Act is that prior to date of transfer, there has to be everyone has to be paid out. So on one hand, there's a level of protection for all the parties that we've mentioned, and it's a level of protection that firstly definitely wasn't there in terms of the expropriation, in terms of the old Expropriation of Land Act. So the question is, when you say where's all that money going to come from, the answer is very simple.
Tax.
Potentially tax. Also, it's going to mean that there's going to have to be a greater level of discipline with regards to government spending.
But who will decide what is the value of each farm?
So the truth is that there are criteria, right, which need to be considered, right? There's a whole list of things that need to be considered, right? And it takes into account, and one of the things that it takes into is the actual market value of the property, which is, in a willing buyer, willing seller model, how much would that property achieve if one were to sell it? There are other things that have to be taken into account. When you're talking about a farm is going to be utilized. If you're purchasing a farm for the purpose of utilizing it as a farm, it's not talking about converting that farm into a shopping mall. So the fact that it's going to be utilized for that purpose means that there is going to have to be a greater level of compensation. Now, if the amount that is offered by the expropriation committee when they try to initially do the expropriation isn't sufficient, they're then going to have to hand it over for adjudication and whatnot. And ultimately, the final point of consideration is going to rest with the courts. It's going to be one of those situations where the vulture bias are going to be the big ones who win, fortunately. It's a funny joke. I'm happy that one woman got it. Thank you very much, everyone, for coming. I hope it was useful.